dear students, last session we were discussing the chapter Human Rights and Environment. Today this session will be relating to the Judicial Activism and Environment. The objectives under this lesson are to understand the scope of public interest litigation, to understand the need for judicial activism, to understand the impact of international environmental law on Indian courts, to understand the analyzing powers and prowess of Indian judiciary in various landmark decisions on environment protection. First, let us deal with the introduction of the lesson. The Supreme Court of India opened the floodgates to public interest litigation. Under public interest litigation, courts take up cases that concern not the rights of the petitioner but of the public at large. The liberal interpretation of the locus standi in public interest litigation, under which any person can apply to the court on behalf of those who are economically or physically incapable, has served the purpose of public interest litigation. Judges themselves have in some cases initiated suo motu action based on newspaper articles or letters received. In pill cases where the petitioner is not in a position to provide all the necessary evidence, courts have appointed commissions to collect information on facts and present it before the bench. Public interest litigation means a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. The courts monitored implementation of existing laws and policies and issued directions in various types of cases to ensure a safe and clean environment along with development. For the first time, indication towards a wholesome environment as part of life was given in the R.L. Kendra, Dehradun vs. State of UP, AIR 1985, SC 1259, popularly known as Dehradun Quarrying Case. The case categorically emphasized that the right to life without clean and hygienic environment is meaningless. In this case, the court observed that industrial development is necessary for economic growth of the country. Awareness and special education system relating to the environmental law and its protection can be taken to enhance its strong base. Now let us know the scope of public interest litigation. Instead of an adversarial setting where the judge relies on the counsels to produce evidence and argue their cases, the public interest litigation cases are characterized by a collaborative problem-solving approach. The adjudication and monitoring of environmental cases has also benefited from the inputs of fact-finding commissions and expert committees which are constituted to examine a particular environmental problem. In several cases, the courts also relies on the services of the leading members of the bar who render assistance in their capacity as amicus curiae. The involvement of expert committees and amicus curiae is needed to gain an accurate understanding of an environmental problem and to explore feasible solutions. For instance, court appointed committees have conducted substantial empirical research and provided valuable insights in cases that have dealt with vehicular pollution, solid waste management and forest conservation. One can broadly conceptualize these judicial approaches under three categories. The first of this can be described as a pro project approach wherein judges tend to emphasize the potential benefits of a particular project or commercial activity. The second approach can be described as that of judicial restraint, wherein judges defer to the determinations made by executive agencies and experts with regard to the environment feasibility of a project. The third approach is that of rigorous judicial review, wherein judges tend to scrutinize the environmental impact of particular activities. It is in this form of judicial interventions that the services rendered by expert committees, amicus curiae and public spirited non-governmental organizations prove to be a valuable asset. In the ensuing years, there appears to be a growing consensus amongst the media and in academic circles that the general approach of the higher judiciary in environmental litigation can be described as activist in nature. The articulation of the absolute liability doctrine was soon followed by the recognition of the polluter pays principle. This development proved to be a precursor for subsequent decisions which recognized principles such as sustainable development and intergenerational equity. While the media has focused on the principle in respect of developmental activities that may harm the environment and the local communities, while policy making in this regard has also evolved with the requirement of environmental impact assessment before the commencement of construction activities, judicial oversight is still needed to ensure that the same is conducted in a transparent and consultative manner. The impact on the local communities can only be accurately assessed if their concerns are effectively heard through methods such as public hearings. Now let us know the need for judicial activism. The philosophy of public trust finds place in our constitutional commitments, and our judiciary is committed to upholding the same. This is precisely why judges are frequently called on to weigh individual interest on the scales of social justice. In 1982, the Supreme Court conceded that unusual measures were warranted to enable people the full realization of not merely their civil and political rights, but the enjoyment of economic, social and cultural rights. And its far-reaching decision in the case of PUDR, People's Union for Democratic Rights versus Union of India, it recognized that a third party would directly petition, whether through a letter or other means, the court and seek its intervention in a matter where another party's fundamental rights were being violated. As the Supreme Court noted, the rule of law does not mean that the protection of the law must be available only to a fortunate few, or that the law should be allowed to be exploited by the vested interest for protecting and upholding the status quo under the guise of enforcement of their civil and political rights. The poor too have civil and political rights, and the rule of law is equally applicable to them also, though today it may exist only on paper and not in total. Traditionally, the right to move the Supreme Court was only available to those whose fundamental rights were infringed. But this traditional rule was considerably relaxed by the Supreme Court in certain cases which are discussed below. In Shriram Food and Fertilizer case, AIR 1986 to SCC 176, the Supreme Court of India, through a public interest litigation, directed the company manufacturing hazardous and lethal chemical gases was directed to take all necessary measures before reopening the plant to avoid prevent danger to life and health of the workers. In Indian Council for Environment Legal Action versus Union of India 1996 5 SCC 281, public interest litigation was filed by a registered voluntary organization regarding economic degradation in the coastal area. The Supreme Court issued appropriate orders and directions for enforcing the laws to protect the ecology. In State versus Union of India, AIR 1996, CL 8181, Supreme Court held public interest litigation is a strategic arm of the legal aid movement which intends to bring justice. A bill was initiated by lawyers B.L. Vadera and Almitra Patel against the growth of slums. The Supreme Court directed the departments to take appropriate action to check the growth of slums and to create an environment worthy of living. In welcoming public interest litigation, the court attempts to ensure observance of social and economic programs framed for the benefits of the underprivileged citizens and the handicapped. Public interest litigation has proved to be a boon for the common citizens. It has set a number of wrongs committed by an individual or a society right. By relaxing the scope of public interest litigation, the court has brought legal aid at the doorsteps of the teeming millions of Indians, something which the executive has not been able to do despite money being spent on new legal aid schemes operating at the central and state level. Supreme Court's pivotal role in expanding the scope of public interest litigation is laudable. Impact of international environmental law on Indian courts. In the middle of 1980s, the Supreme Court of India and several high courts began to make reference to international instruments in their various decisions. Indian judges are able to reach innovative and far-reaching decisions on environmental matters on the basis of constitutional provisions. It was observed that quite often international instruments are invoked in the context of judicial reasoning, which ultimately depends upon interpretation of the right to life under Article 21 of the Constitution of India, which has been further interpreted to include the right to healthy and decent living environment. Prior to the year 1996, there were a few references to international environmental treaties, although India was a party to many of the multilateral treaties of environmental significance. In the case of People's United for Better Living in Calcutta versus Union of India with petition 461 of 2013, reference was made to the provisions of Ramsar Convention 1971, which referred to an environmental treaty arose in a case regarding the preservation of wetlands surrounding Calcutta. The High Court of Calcutta noted that India is a contracting party to the Ramsar Convention, under which she is obliged to promote the conservation of wetlands habitat in her territory. It is pertinent to mention that the Salt Lake Swamp in the city of Eastern Calcutta was listed in the Directory of Asian Wetlands and is listed as a wetland of international importance under the terms of Ramsar Convention, which was noted by the court. The crux of the judgment is that it gives legal effect to the obligations in the Ramsar Convention 1971. The principle of intergenerational equity embraces the idea that the present human generation holds that Earth's resources in trust for future generations. In Valued Citizens Welfare Forum versus Union of India 1996 5 SCC 647, the Supreme Court of India has made reference to the principle of intergenerational equity as a salient principle of sustainable development. Further, in this case, the court recites the Brundtland Commission's definition of the sustainable development as development which meets the needs of the present without compromising the ability on the future generations to meet their own needs. The concept of intergenerational equity brought into the limelight by the High Court of Calcutta in People's United for Better Living in Calcutta versus State of West Bengal 1993 1 CL 105 1993. In this case, the Calcutta High Court held that the present day society has a responsibility towards the posterity for their proper growth and development so as to allow the posterity to breathe normally and live in a cleaner environment and have consequent fuller development. Judicial activism may be defined as a philosophy of judicial decision making whereby judges allow their personal views about public policy among other factors to guide their decisions. Now let us know about the landmark judicial decisions on the area of environment protection, which will tell us about the judicial activism. India has enacted various laws at almost regular intervals to deal with the problems pertaining to environmental pollution. At the same time, the Indian judiciary has played a pivotal role in interpreting the laws in such a manner which helped in protecting the environment. In fact, the Indian judiciary has created a new era of environmental jurisprudence. Some of the case laws discussed in this regard are Sachidanand Pandey versus State of West Bengal, AIR 1987 SC 1109. The question raised in this case was whether the government of West Bengal exhibited a lack of awareness of the problem of environment in allotting land for the construction of a 5-star hotel at the expense of the local zoo. The construction of the hotel would obstruct the flight path of the migratory birds. The court held that the West Bengal government acted perfectly bona fide in granting the lease of the land to the hotel. The proposed hotel is a garden hotel and there is perhaps every chance of the ecology and environment improving as a result of planting of numerous trees all around the proposed hotel and the removal of burial and dumping ground. In the Indian Council for Enviro Legal Action versus Union of India, AIR 1996, Supreme Court 1446, the writ petition filed by an environmentalist organization brings to light the woes of people living in the vicinity of chemical industrial plants in India. The problem began somewhere in 1987 when Hindustan Agrochemical Limited started producing certain chemicals. The real calamity occurred when a sister concern, Silver Chemicals, commenced production of H acid in a plant located within the same complex. Its manufacture emitted enormous quantities of highly toxic effluents, in particular iron-based and gypsum-based sludge, which if not properly treated pose grave threat to Mother Earth. Since the toxic untreated wastewater was allowed to flow out freely and the untreated toxic sludge was thrown in the open in and around the complex, the toxic substance percolated deep into the bowels of the earth, polluting the aquifers and the subterranean supply of water. The soil has become polluted, rendering it unfit for cultivation. The main stay of the villagers. It has spread disease, death and disaster in the village. The court held in this case, while overruling objections against various reports submitted by Neary, the court has given directions which are mainly as under. The central government was constitutionally empowered to issue remedial directions, and it shall determine the amount required for carrying out the remedial measure. Closure of plant and factories of rogue industries. Villagers of the affected areas are free to claim damages for the loss. Another famous case is Narmada Bachao Andolan versus Union of India, AIR 2000, SC 3751. In this case, the Supreme Court held that the precautionary principle and the corresponding burden of proof on the person who wants to change the status quo will ordinarily apply in case of pollution or other project or industry where the extent of damage likely to be inflicted is not known. Where there is a state of uncertainty due to lack of data or material about the extent of damage or pollution likely to be caused, to maintain the ecology balance, the burden of proof that the said balance will be maintained must necessarily be on the industry or the unit which is likely to cause pollution. On the other hand, where the effect on ecology or environment of setting up an industry is known, steps must be taken to off or set the same. The construction of a dam undoubtedly would result in the change of environment, but it will not be correct to presume that the construction of a large dam like the Sardar Sarovar will result in ecological disaster. India has an experience of over 40 years in the construction of dams. The experience does not show that construction of a large dam is not cost effective or leads to ecological or environmental degradation. On the contrary, there has been ecological upgradation with the construction of large dams. What is the impact on environment with the construction of a dam is well known in India. The Indian Constitution is amongst the few in the world that contain specific provisions in environmental protection. The directive principles of state policy and fundamental duties explicitly enunciate the national commitment to protect and improve the environment. Judicial interpretation has strengthened this constitutional mandate. Now, let us also deal with some of the latest cases on environment protection. In Adivasi Mazdoor Kisan Ekta Sangathan and another versus Ministry of Environment and Forest and others, Appeal number 3 by 2011 T NEAA number 26 of 2009, Judgment of Principal Bench of the National Green Tribunal on April 20, 2012. The case of the appellant was that the environmental clearance was granted to the project without properly conducting the public hearing. Conduct of public hearings in an improper manner has also emerged as a common ground for challenging environmental approvals. In this case, the evidence of persons who voiced their opposition to the project was not recorded, and no summary of the public hearing was prepared in the local language, nor was it made public. Therefore, the court declared the approval as invalid. Deepak Kumar versus State of Haryana and others, special leave petition, civil number 19628 to 19629 of 2009. Judgment of Supreme Court on February 27, 2012. In this case, referring to the recommendations of the Committee on Minor Minerals, the court underlined that state government should be discouraged from granting a mining license or lease to plots less than 5 hectares so as to reduce circumvention and ensure sustainable mining. Further, where land is broken up into smaller parcels, prior environmental approval should be sought from the Ministry of Environment and Forests. Animal Welfare Board of India versus A. Nagaraja, 2014, 7 SCC 547. This case is filed for recognizing the rights of animals under our constitution, laws, culture, tradition, religion and ethology, which we have to examine in connection with the conduct of Jallikattu, bullock cart races in the states of Tamil Nadu and Maharashtra, with particular reference to the provisions of the Prevention of Cruelty to Animals Act 1960. The Tamil Nadu Regulation of Jallikattu Act 2009, for short TNRJ Act, and the notification dated 11/7/2011 issued by the central government under section 22, clause 2nd of the Prevention of Cruelty Against Animals Act. The state of Tamil Nadu has also taken up the stand that every effort shall be made to see that the bulls are not subjected to any cruelty so as to violate the provisions of the PCA Act, and the sport event can be regulated as per the provisions of the TNRJ Act. But the court found that there is inconsistency between section 5 of the TNRJ Act and section 11, clause 1, clause M, clause 2nd of PCA Act. The court held that Animal Welfare Board of India is right in its stand that Jallikattu, bullock cart race and such events per se violate sections 3, 11 clause 1 clause A and 11 clause 1 clause M and clause 2nd of PCA Act, and hence they upheld the notification dated 11/7/2011 issued by the central government, consequently stating bulls cannot be used as performing animals either for the Jallikattu events or bullock cart races in the state of Tamil Nadu, Maharashtra or elsewhere in the country. Sunil Kumar Chugh versus Secretary, Ministry of Environment and Forests, New Delhi, Appeal number 66 of 2014. In this judgment, the matter decided by the National Green Tribunal held that open spaces, recreational grounds and adequate parking facilities in buildings had an important bearing on the right to life of people. This ruling is indeed an important step forward in the effort to save India's cities from the degrading effects of illegal construction and haphazard urbanization, which have so far continued unabated. In Sterlite Industries India Limited versus Union of India 2013 AIR SCW 3231, the Supreme Court discussed the specific grounds on which administrative action involving the grant of environmental approval could be challenged. The grounds for judicial review were illegality, irrationality and procedural impropriety. Thus, the granting of environmental approval by the competent authority outside the powers given to the authority by law would be grounds for illegality. Orissa Mining Corporation Limited versus Ministry of Environment and Forests and others, writ petition Civil number 180 of 2011, judgment of the Supreme Court of India on April 18, 2013. In this case, it was decided that the Gram Sabha is obligated to safeguard the traditions and customs of the scheduled tribes and other forest dwellers as mandated under both the Forest Rights Act 2006 and the PESA Panchayats Extension to Scheduled Areas Act 1996. Underlining this role of the Gram Sabha in this case, the Supreme Court has ruled that the religious rights of individuals and communities to be determined by the Gram Sabha would have to be protected, and therefore the decision of the Gram Sabha would have to be considered before the Ministry of Environment and Forests grants environmental approvals for developmental projects in forests or scheduled areas. Dear students, today's session we have discussed about the judicial activism and environment. I hope you have enjoyed this session. In the next session, I will be dealing with the future challenges and environment protection. Thank you.